up all the Act sections, and important sections are provisions and words are important to remember. For MCQ, it's very important that we should know what are the parts of an act and how it works, how they are divided, and the structure of an act, and for what reason it was enacted, when it came into force. That is also we should know. For all law exams, this is very important. For LLB and all the law exams, it's very important. For MCQs, we should know what is the act. Even if it is with the exam, with the books, for AIB, it may not be for next year. Now, this year itself, I was in fear that we may not have the luxury of having books in our hands. So I think we should know what are the acts and how the sections divided and what are the parts of the some acts which are important. So we'll go for Indian Evidence Act 1872, important section for all the exams. As I said, it is very important section and how you should remember it. Where the sections are, where how the parts are divided, at least we should know the sections name itself. We don't remember that also. So we'll go for this, and I'll make a short video and we'll continue after some 5 or 10 slides so that it will not be boring. So for that matter, I'll just explain this. Indian Evidence Act, originally passed in India by the Imperial Legislative Council in 1872. It's very sturdy and a good act in that sense. It has worked for more than 140 years. Now, it was enacted in British Raj as a set of, it contains a set of rules and allied issues governing admissibility of evidence in Indian courts of law. For this year, in the August 2023, the bill is there to replace this by the Bharatiya Saksh bill, which is still pending, and that is the bill is for still is to come into force. We'll study this act and we'll just go through it. So this Indian Evidence Act 1872 is Act number 1 of 1872. So this is Act number 1 of 1872. There is another Act of Act number 4 of 1872. You should just remember that it was enacted in the same year, and that is, I must tell you, that is Transfer of Property Act. The same year it was enacted, and this was passed in 15 March 1872 and came into force on the first day of September 1872. So we should remember this also. The came into force in the 1st September 1872. So there are total parts 11. 11 parts है और 167 total section है. But it all comes total into 185 as in amendment. As you know, there are IT Acts came into force in the year of 2000. Due to this, there are some section amended and added to this act also. So total sections are 167, but it came into total with amendments 185. With this, we go for the first slide. Chapter 2. This is the chapter 1. We should go for this first. Okay. Section 1, extent of Indian Evidence Act. This is whole India. It is whole India. And section 3 of Indian Evidence Act is very important. It is having interpretation clause. So even if you have the bare act in your hand, we should know what the section contains. At least we should know the title of that section. So when you just go through this video once again, twice, thrice, whenever you are having any other work, or while traveling also you can listen it. तो काम करते करते 2-4 बार अगर हम लोग इसको सुनेंगे तो listening is another form of studying. When you see, when you hear, you remember the facts, the things very easily. So the section 3 will go for all the sections of 167, wherever the mention of these all 10 explanations are there in section 3. सेक्शन 3 इंटरप्रिटेशन क्लॉज है, जिसमें हमको 10 एक्सप्लेनेशन देखने को मिलते हैं, जिसमें as it is given in the list: quote, what is the fact, relevant, fact in issue, what is document, what is evidence, what is proved, disproved, not proved, and at last is 10th is India. So wherever these words are mentioned in this act, the explanation we should find in section 3. So it is very easy, otherwise it will be more bulky. अगर every time what is quote ये mention किया जाता तो ये बहुत bulky act होता. So these are the 10 explanation in interpretation clause of section 3. So remember all these 10 words: quote, fact, relevant, fact in issue, document, evidence, proved, disproved, not proved, India. All these explanation given in interpretation clause. So index specs question में हम लोगों को पूरे marks मिलना चाहिए. Section 4 is, as it is the title is given, may presume, shall presume, conclusive proof. So court may presume fact as it is given in sections. Presumption sections है section 86. As the title says, presumption as to certified copies of a foreign judicial record. Court may presume. तो may presume वाले section कौन कौन से है? Section 87, 86, 87, 88, section 88A, section 89, section 90, 90A, section 113, section 114. So these are all the sections where court may presume fact. So I'll just read it out. Section 86 is presumption as to certified copies of foreign judicial records. Court may presume that they are correct. Presumption as to books, maps and charts. Section 87. Presumption as to telegraphic messages. Section 88A of presumption as to electronic messages. This was added in year 2000 with IT Act's amendment. So electronic messages presumption is court may presume the fact that they are correct. Section 89. Presumption as to due execution etc. of documents not produced. Section 90 is presumption as to documents 30 years old. They are treated as true, but not the contents. Please remember this. The contents of 30 years old documents, they have to be proved. It is only for the facts of presumption of the court that they are true and relevant to the case. Section 90A. Section 90A is for presumption as to electronic records of 5 years old. So we'll go for the next slide. Section 5. Evidence of person. All statement of witness here to say. So oral statements made before police are not admissible. Section 3 says court includes all judges, magistrate, all person legally authorized to make evidence. It was the question asked in 2000, that 17th AIV. So I just added this. It was asked in one question as court includes all judges, magistrates, all person legally authorized to take evidence, and but it will not include arbitrators. So court will not include arbitrators. Section 3 says that. So just, yeah. Section 24. Whatever important sections and keywords I have mentioned here, so that you will just go through it and remember it whenever you need it. But these are the keywords you should remember about the sections. Section 24. The keyword is inducement. It is about the confession which is not relevant. Whenever there is a inducement in the confession, it is not relevant. The confession will not be relevant in evidence. Section 25. Police. When they are recording confession, it is not relevant. It will not be taken as true. They must have some, they have to prove it. Section 26. Police custody. Wherever a person in police custody gives any statement of confession, it will not be treated relevant, as it may be taken due to some force. Definitely, it is just a natural thing in mind comes into. जेव्हा पोलीस कस्टडीमध्ये एखादा माणूस असतो तेव्हा तो फोर्सिबली एखादी गोष्ट कन्फेस करू शकतो, आणि तो केल्यामुळे किंवा तशी शक्यता असल्यामुळे it is treated as not relevant. It is just a statement, not confession. But there is an exception to section 26. When it is the confession is given before the magistrate, it will be relevant. So please remember this. Section 26 exception आहे. मॅजिस्ट्रेटच्या समोरचं कन्फेशन रिलेव्हंट आहे. Section 27. When there is a discovery after a confession, it will be treated as relevant. So 27, 28, 29, 30. 4 sections are there where the statement of confession is relevant. एखादा अपराधी जब वो बोलता है कि कन्फेशन में कि I have kept my whatever he has used for the offense, the instrument, and वहां पे छिपा के रखा है. If the police goes and find out that instrument with which the offense was made, and if it is found there, that part of confession will be relevant, because police did not know which it was kept. They goes with the person and they found out एखादा चाकू छुरी जो भी यूज किया है, रिवॉल्वर, whatever he has used, it will be relevant. That part of finding that thing which is relevant. So for section 27, discovery is the word. Discovery is the keyword for confession to make it relevant. Section 27, inducement when removed. So inducement, whenever there is inducement, it is in section 24. The confession is not relevant, but section 28 says it is opposite of 28. This 24 say 28. इसमें whenever their inducement is removed, it will be relevant. The statement of confession will be relevant. Section 29. Promise, etc. Secrecy. With this secrecy, promise and all other things, whenever the police says कि हम लोग आपका सजा कम करेंगे, and any kind of threat is given, or promise is given, the confession, the promise, etc., secrecy, it will not be relevant. Section 30, co-accused confession. Co-accused confession, when there are so many people involved in a crime, 4-5 people, and one of these 5 people, one person gives confession in a joint trial, confession of accused can be used, and that is relevant. So this is very important for section 30. Co-accused, when he says something about the case in a joint trial, it will be relevant. We'll go for the next slide and stop this only. After this, we'll just continue in the next video. This is chapter 4. There are 11 chapters, as I initially only said. 11 chapters है इसमें. इंडियन एविडेंस एक्ट में टोटल पार्ट्स है 11 पार्ट्स में है चैप्टर्स. तो टोटल सेक्शंस 167. Chapter 4 is of oral evidence. Evidence can be given by any person or witness. Person is a witness who gives statement about any fact in issue. So it must be direct. The oral evidence, hearsay evidence will not be allowed. So section 59 is proof of facts by oral evidence. The title is proof of facts by oral evidence. So oral evidence, how it should be? Direct. So in any question, if the question comes about the oral evidence, it should be direct. Hearsay evidence will not be taken in the court. So if someone hears कि उसके फलाने ने ये किया, मैं ये बता रहा हूँ, तो ये truth नहीं है. Unless he goes there, if he finds there that thing with his eyes and finds that is by senses, then only it can be treated as direct evidence and it will be treated as evidence. Section 60, statement of documentary section के बारे में. Section 60, oral evidence must be direct. So 59 is about the proof of facts by oral evidence. There are only 2 sections in chapter 4 where about oral evidence it is clarity is given. We'll go for this slide and then stop. Section 61 to 65, it is about primary and secondary evidence. This is chapter 5 and the title of chapter 5 is documentary evidence. Chapter 4 is of oral evidence. So you just remember about the chapter's titles. It's very important that we should know in which chapter, what sections are there and about the titles. So इंडेक्सिंग में अगर आपको ढूंढना है तो थोड़ा बहुत चैप्टर का नाम and the sections title, what it is in you, if you don't know, is fine. That depth is not asked in that, but at least you should know what is the title of section and what is the chapter and what are the contents. So primary or secondary evidence 61 to 65 in chapter 5, which is talking about of documentary evidence. So how the documentary evidence should be taken. So 61 says about proof of contents of documents, 62 about primary evidence, 63 about secondary evidence, and 64 proof of documents by primary evidence. In 65 cases in which secondary evidence relating to documents may be given. Section 66 talk about notice. So these are the points to remember in section 61 to 65 of chapter 5, which talks about the documentary evidence. So we'll stop here, and in the next video we'll continue about these things. So thank you very much. We'll continue. If you want to continue and about the IT Act, please comment, because IT Act has so many sections inserted in Indian Evidence Act, which gives effect to the electronic records and how it should be taken. So we'll go in the next video about all these things. But especially if the amendments about the IT Acts to be in one video, please comment that we will make it. Otherwise, we'll just drop it and go ahead with all the sections. So chapter 5 till now, we have completed some important sections. Thank you very much. We'll continue in the next video. Please like, share, subscribe. Thank you.